Thank you for watching the Housing Oregon YouTube channel. Be sure to join our network and get involved in the work that we are doing. If you can, please like and subscribe. It helps us build this channel, which serves as a platform to communicate with our members. This video is part of our 2025 annual conference. We're looking for folks to be on the conference planning committee. Please email info@housingoregon.org.
Okay, we're going to get started just so we can time-wise get through this. Good morning, all three of you. Thank you for finding this room successfully. I also had trouble with it, so thank you so much. My name is Savannah, and this is my co-presenter, Glenda. And we are from the Fair Housing Council of Oregon, the Education and Outreach team, and we are super happy to be here. See if I can get my mouse to work. So, today, we're just going to go over basics of fair housing, protected classes, how all of it works, what they are, and what they mean. And we'll go over our explanation of the Fairview Trust Grant work that we did. So in 2024 to 2025, we were awarded the Fairview Trust Grant for work involving what you will see regarding the IDD community, individuals with intellectual and developmental disabilities. And it's actually a lot of new work that we did. The materials that I gave you guys, let me give you some. These materials are brand new. We just created them in May. They were publicized, I believe. And it was really amazing because we got to do a lot of work around learning about the community, research, listening sessions, and I think it was pretty insightful for our team. So you can click for me if you want.
Oh, no, you can click.
I'll just walk around. Helps my ADHD to walk around.
I got you.
Okay, so fair housing law is under the Civil Rights Act. There was the Fair Housing Act of 1968, and fair housing law is the right of all people to be treated equally in all actions involving the rental, sale, or financing of housing, or we like to call it housing transactions. So what fair housing does, it establishes that it is illegal for housing providers to discriminate against protected classes. And in the rental, fair housing laws cover the application process, tenancy, move out, evictions. It covers everything from the time you walk into the landlord's door to apply to the time you're out of your unit. Whew. Sorry, I'm really, really hot.
You just covered that, so we'll keep on going.
So discrimination defined in fair housing is treating a person differently. And notice it doesn't say treating them badly, it says treating them differently. In any housing transaction because of that person's protected class. And what protected classes are, excuse me. So in 1968, when the Fair Housing Act was initially passed, it was passed with 4 protected classes, which were race, color, national origin, and religion. Also, fun fact, the Fair Housing Act was passed exactly 1 week after the death of Martin Luther King, and it was passed as a result of the death of Martin Luther King as Congress's way to try and quell the unrest that was happening throughout the country. And then we have the protection of sex, which includes currently, under the administration, male and female. However, there are state protected classes, and we'll kind of get into that as well. And that was added as part of the women's suffrage movement. Women were not allowed to rent housing because they were women, because, oh, well, there's a really big lawn and we don't think you can mow it, or, oh, you're a single mom with a couple kids. I, as a landlord, don't support that. So they could legally just simply deny people housing for that reason. And then we saw the addition of familial status, which in fair housing is defined as families with children. And family is a broad definition that could be a single mom with a foster child. It could be an aunt who has her nephew living with her and has, temporary custody, guardianship. It is very, very broad, families with children under the age of 18. And then disability, which is probably the most widely The wide spectrum class, it's what we actually get most of our work is around disability, which is why the Fairview Trust work was really awesome because we got to delve into IDD and it allowed us to really get into kind of a subsection of the disability community that is often overlooked. So Oregon, as a state, is also allowed to create their own protected classes based on whatever need they believe they have. So what Oregon has done is they've created marital status as a protected class, which means whatever your marital status, lack thereof, relationship status, it cannot be used against someone and they cannot be treated differently because of it. So what that means is they can't ask if I'm married on an application. If I walk into a room with someone next to me and I say we want to rent an apartment together, they can't ask, oh, is this your sister? Is this your husband? Is this so-and-so? Because that would potentially give them information that may cause them to treat you differently. There's also a source of income.
Oh, sorry.
Oh, you're okay. There's also source of income, and what source of income means is people who receive any kind of housing assistance. That means Section 8 vouchers, housing choice vouchers, any kind of promissory notes, tribal rental assistance. As a landlord, regardless of if they have 5 units or if they run a 60-unit multifamily complex, they have to accept those pieces of, like, those vouchers as part of that rental obligation. And this is a pretty big problem in a lot of rural areas because there are people that go through housing agencies, that go through different agencies and have different types of rental assistance. And oftentimes landlords will not accept them because they don't even identify what they are. There's also sexual orientation, gender identity, which is protected in the Oregon legislature as well. Excuse me. And so what fair housing actually applies to is kind of everything. If someone posts an ad on Facebook for an apartment for rent, even though they're not posting it on rent.com or on Zillow, they still have to follow fair housing law in their advertisement. They can't say, you must be over the age of 25 and white and female. That would be potentially violating multiple discrimination protected classes. And it also applies to every interaction in person, every interaction on the phone, emails, text messages, interactions with staff, maintenance workers, anybody. It applies to everything. Hello. Hello. That, you know, we had the same problem. That is okay. We have materials on the table up here. Feel free to come up and grab them. It's a small group, so I'm just walking around and talking everybody's ears off. Fair housing also applies to dwellings. So in the world of fair housing, it's a little bit different than some local municipalities or some other laws and ordinances may define or kind of categorize dwellings. But in fair housing, a dwelling is essentially a room, structure, building, apartment, townhome, in some cases an RV, manufactured home that is intended to be a home that is lived in. It is a very simple definition, it's very broad, but it is also not specifically defined. There's a lot of case law around it, and if you have more questions, please see our information table. Any questions so far? That's our first break. Okay, perfect. So with Fairview Trust, we actually began with listening sessions because you can't really do any work until you understand what the needs of people are. So we did listening sessions via our community advisory groups that we do quarterly. We did targeted listening sessions to advocates, to people that work with people with IDD, direct support professionals, personal support workers, people living with IDD, people in the community who are self-advocates or who are family members and caretakers of people with IDD, to try and find out what they have in housing, what their experiences are, what their barriers are, and where we are missing those gaps in information and how we can help. And it was pretty amazing to have those conversations. We had a lot of one-on-one conversations with people, listening to how barriers to housing completely changed their lives, changed the trajectories of their lives, changed the trajectories of their children's lives, And a lot of it was discriminatory or potentially discriminatory, but because they are so used to being treated a certain way, they are used to it. Some of the themes from those listening sessions was in specifically regards to property management and landlords not knowing or not understanding certain laws like reasonable accommodations and modifications, people putting in requests. There were a lot of cases of discrimination that were potentially even based off of just a lack of information and lack of understanding on the landlord side. Also accessibility. And accessibility is not a one-size-fits-all. It is completely different depending on that person's lifestyle and how their disability affects them. And also non-accessibility housing characteristics. So as we know, a lot of housing is not really designed for everybody. People who have neurological disorders, developmental disorders, sensory processing disorders can be in different types of housing, and those environments, I hope this isn't dying. Those housing environments can actually be triggering, they can overstimulate, they can actually be worsening someone's disability depending on the environment they live in. So it is very, very important. And also policy. There is a serious lack of policy around IDD, and a lot of it is because there is a lack of understanding and awareness between the community of people living with disabilities, specifically IDD, and the policymakers who do not understand probably the impact and the needs of housing of those people. And so part of what we have been doing also is doing research, hearing people's stories, and hopefully we'll be doing some, excuse me, I'm like trying not to lose my voice here. And hopefully we'll be doing some policy work. Who are we working with when we were, was it Disability Rights Oregon? We did some work with Disability Rights Oregon. They are really, really good policy advocates. If you check out their website, they actually have some resources on current policies and bills that are trying to be presented up into the legislature, and they're doing some really good work. And then the number one problem, affordability. Because we all know that disability is a lot of money, and you can just, go on vacation to Hawaii every month. Oftentimes, disability is not even enough to cover rent for a 2-bedroom apartment in any county in this state. And it is extremely, extremely tragic because there are many people who do not have housing, or they are forced to live with relatives or friends or caretakers because they have no other choice. In regards to property management and landlords, there are a lot of barriers to people with IDD. Part of it is because when people have intellectual and developmental disabilities, categorically, there are people with lower IQs, lower comprehension levels, different types of learning styles. Property management and landlords often do not have the capability or the foresight to accommodate anyone in that process. There's also a lack of advocate and support professionals who can help. They're understaffed and they're underpaid. There are communication issues between landlords and tenants, recertification challenges, landlords not getting the proper information not being communicated between advocates, between landlords, between tenants. There's also maintenance problems. People maybe don't report maintenance. They don't identify that there is a maintenance issue, so they don't report it. There could also be presence at properties. There could be people who do not get along with people. There can be people who do not like animals, who don't like any kind of animals, people that don't like noise, and if they live in environments where those things are happening, they can be easily overstimulated. And there's a lot of other things too. I can't think of them off the top of my head, but in our guide and in our brochure, it covers a lot of the actual processes, because that is the really important part to know, is the processes and the definitions and what everything actually means. So discrimination, again, being treated differently, not necessarily being treated badly. People can discriminate with the best of intentions. There might be someone that says, hey, you know what, I understand that you have these specific needs, that you have, X, Y, Z. I really think that building B over there next to the playground or next to this would be the best place for you. Even though you really want to look at unit D, I don't think that's a good fit for you. That would mean that landlord, maybe they're trying to help that person, but they are steering them in the direction that the landlord wants them to go. And they are not allowing that person to have their choice in where they want to live, which is also called steering. There's also unfair treatment, issues in people reporting discrimination. If they don't know if they are being discriminated against, they're not going to report it, and they may not even know where to report it or how to report it. Issues with maintenance, again, if they do not know it's a problem, they're not going to speak up. If they do not understand how to speak up, or if they don't know the process, they're not going to be able to do it on their own. And a really important aspect of this is support workers. Personal support workers and direct support professionals that work directly with people in housing who can actually help them navigate these processes are very, very important, and they are unfortunately underpaid. Oh, goodness. I'm losing my voice. Yeah. For accessibility, we often think of accessibility as a mobility problem. Accessibility. This door is not wide enough for a wheelchair to fit through. There's not a ramp up these stairs. But accessibility does not just apply to the physical. It applies to the mental, the emotional, and the cognitive abilities as well. So there are certain things that people need. Housing is where we are supposed to be able to be ourselves, be comfortable, and be safe. And oftentimes people cannot get all of those needs met because they have things that they need to ask for and they don't know how. They also might need needed features. Maybe someone is deaf or even partially deaf, and they need one of those smoke detectors that strobes if the fire alarm goes off, and it will wake you up out of a dead sleep. Also modification requests. Requesting modifications can be really challenging, especially if they don't understand how to ask for them or what modification might be needed to actually solve that problem. One example I can think of, I worked with a mom with an autistic daughter, and she had these very intense, energetic moments at night where she would, as her mom put it, bounce off the walls, quite literally. She'd be very loud, and even though she lived in a manufactured park where she had her own home, her neighbor could hear her daughter at 10, 11, 12 in the morning. And so they started giving notices. She got a notice, got another notice, and she got a final notice that said the next violation will be an eviction. And she was terrified because she could not afford to move that home. She was going to leave, and that was going to be it. And I helped her come up with a request to get soundproof paneling to put on the walls, so that it insulated the walls where the neighbor was and potentially saved her from eviction. And it was a very simple solution to a problem that was potentially life-altering. It's fine. I was saying common area pathways. If you live in really old housing with the really narrow stairs where the staircase is only about 24 inches wide, and as a kid you used to almost die in the dark, sometimes those things cannot be changed. You can't change, the physical structure of the building until you remodel, so those are challenges as well. And non-accessibility housing characteristics, there are safety concerns, traffic transit and ambient noise. If you are living in a housing that is located 50 feet away from a train track, it's probably not a great idea for someone with sensory issues to live there, but maybe they don't have a choice. They may need to ask for an accommodation, or they may need to change the layout or change something in order to live. Access to services can be a big issue, especially in rural areas, because if they cannot drive, or if they cannot, barely afford to live, and they can't afford the gas to go 40 miles into town each way every day, they're not going to get the services they need. And then with policy, so policy is hard because in order to enact change, you need to bring information to the people that can make that change, and you need to convince them that making that change is going to be what's best for everybody. And that is often very difficult. There's also issues with supply. Housing supply is at an all-time low. Homelessness is skyrocketing because people simply cannot afford to live. And it's really difficult to enact change, significant change, when there is demand right now just for supply. So changing certain criteria to that supply could be detrimental to the way that the legislature wants to enact their housing policies. There can be application barriers. People may not even know that there's programs they can apply for. Finding units, it's very hard to find units. You know, where do they go? Where do they search? Do they Google? Do they Zillow? Where else can they look? And with modifications and care providers, when they are in the home, are the direct person who is watching that person interact and live in their home. Care providers, if they are properly trained and educated, can actually help people identify barriers and help them put in their requests to modify or change or address those barriers in housing. That's a really important aspect of what we have been doing, talking to and training advocates and self-advocates and support workers, because if they have the knowledge to be able to help someone, one little link, one circumstance, one request might change somebody's life. And our lovely best favorite subject, affordability, housing market issues, also disability-related issues. There is not enough accessible housing. The minimum requirement for 5% of accessible housing units in construction does not.
Is that your phone?
No? Having some mystery feedback here.
There you go.
I don't remember what I was saying.
Affordability.
Thank you. So, problem with affordability in housing and accessible housing is if an estimated 1 in 4 people, or 25% of the population, lives with a disability, why are we only creating 5% accessible housing? Why are we continuing to further that gap? That's not also including simply aging personnel. Right now we have more baby boomers aging into retirement age than ever in history. We have the highest aging retirement population right now in history, and we don't have enough housing. So what we learned, other than everything I've presented today, with our listening sessions, we wanted to create something that's actually going to help people. Materials, this amazing guidebook. If you don't have one, please prefer to get one. Glenda created that amazing guidebook. She really put a lot of effort and work into that. And we also have, we have the guidebook. We have trainings. We're going to create some more training slide decks. We have a reasonable accommodation modification brochure that goes over the entire process. And if any questions, we are available. We are the technical support advisors for the Fair Housing Act. We are the people who will help you, who will educate you, and will hopefully help you help someone else. We also have an interactive online tool for our modification and accommodation kind of how-to guide. You can scan the QR code. And we have a flyer for policymakers. Hopefully we'll be having some conversations soon. And overall, I personally am someone living with IDD, and I have 2 children, both with IDD. They are neurodivergent, and I love them, and they are amazing. And I will say that learning as much as I have as a parent with children with IDD and worrying about what would happen if I was put in a situation where I might be evicted or might be houseless because my children needed accommodations, it really hit me hard listening to these stories. And I really hope that you guys appreciate our work, and I'm going to pass it on over after any potential questions.
All right. Does anyone have any questions for Savannah? Okay. We're going to move on in regards to advocacy for people with intellectual or developmental disabilities. Our work with the Fairview Trust was absolutely amazing. We're actually continuing that work now with CUNY Foundation to even go deeper into legit research that's been done regarding people with IDD and how that affects them in housing. So we're just going to move into advocacy. I'm not going to get too much. I'm not going to get in the weeds of that or dive too hard into that right now. But in regards to advocacy in housing, Laws that assist people in housing are, of course, landlord-tenant laws if they're renting, fair housing laws, those the federal, state, and local laws that might be put into place regarding someone's protected class status. ADA law, which is Americans with Disabilities Act, that does actually kind of overlap with fair housing law sometimes, especially if the housing's like an apartment complex, when there's, or, you know, community living type thing, when there's areas that anybody can access, sidewalks, community rooms, parking lots, those public accommodation areas, mailboxes. That would overlap with ADA law and fair housing law. But for the most part, those laws in housing have to do with landlord-tenant law when you're talking about renting, and fair housing laws. And then, of course, there's local ordinance sometimes that provide additional zoning, other types of local ordinance types laws that local jurisdictions must follow. So landlords can treat applicants differently in some cases, okay? So sometimes we get contacted, and we're joined tonight or today by Stephen back here, who is the director of our enforcement team and also an attorney at the Fair Housing Council of Oregon. Thank you for being here, Stephen. He's gonna keep us in check. But oftentimes, you know, we get phone calls from people saying, I've been mistreated by my landlord. And ultimately what it is, they violated their rental contract, okay? And the landlord has every right to hold them accountable for that. So during the application process, the landlord is gonna have policies that they put into play that look at backgrounds, criminal backgrounds, credit history, rental history, maybe the amount of income in the household that they can deny an application based off of their policies, okay? That may not be discriminatory. It might just be what the landlord-tenant law in Oregon allows them to do. In addition to that, landlords can hold tenants accountable when they violate the rental contract. So if they're not paying their rent on time, if they're disturbing the neighbors, damaging the property, or if they're involved in illegal activity, landlords, again, if it violates their rental contract, they have every right to hold that tenant responsible for their behavior. However, house providers need to have the same rules and procedures for everyone and hold everybody accountable in the same way. And that's when fair housing laws get violated, is when the landlord doesn't hold someone accountable in the same way based off of protected class status. So at the Fair Housing Council of Oregon, we pretty much ask two questions in regards to discrimination in housing. Is the housing provider treating the applicant or tenant differently than other applicants or tenants? And if the answer to that is yes, we then ask ourselves, why? Why is that? Is it because of their protected class status, or is it just because the landlord's a jerk, okay? And we can't tie protected class to it, but they're just being a jerk, okay? If we're not able to tie in that protected class status, then most likely it's not going to be a fair housing violation or an issue with fair housing. There has to be a distinct connection between the treatment and protected class status. So examples of discrimination, let's talk about that. It might be that the landlord says at application process when they're doing their background, no criminal history allowed. Well, that's illegal, okay? What that might do is provide some barriers for someone who might have criminal history based off their disability. Okay, let's say it's someone who was actively engaged in their addiction 5 years ago. During that time, they got arrested and convicted of a felony crime. And since that time, they've successfully completed like a substance abuse treatment program. They're no longer using controlled substances, and they're clean and sober, and they can prove it, okay? People with a history of substance abuse or alcohol abuse are protected under disability under the fair housing laws. And if they can show that that criminal history was created by a disability, okay, and provide verification of that they're now clean and sober, there's been a shift or change in their behavior, a nexus, a connection between the criminal history and their disability, they can ask for a reasonable accommodation at the time of application. The thing is, with people who have an intellectual or developmental disability, they may not understand that. And a lot of times people with IDD are victims because they're vulnerable, and they end up getting themselves, like for criminal history, get involved with an issue that becomes criminal, and they get arrested and convicted on that crime because of their vulnerability. So a lot of times when we're talking specifically about IDD, Most often it's because of their vulnerability is why they are in the criminal justice system, okay? And if they can show, or an advocate can help them provide verification of their vulnerability and why they got connected in this situation and got convicted of this crime, they would have, they could ask for a reasonable accommodation at the time of application, asking the landlord to overlook their criminal history. Oftentimes we hear the unit's not available. Someone calls to inquire about an advertisement they saw for some rental housing. The landlord's very talkative, invites them over to see the unit. They show up, and maybe there's something about that individual. Okay, maybe it's very evident they have some kind of disability, and now the landlord becomes aloof. The landlord just stops talking to them, won't return emails, and doesn't really even respond to their application process, okay? That more than likely is discriminatory. And if they can show where the landlord said, was very talkative, very accommodating, come over, please, I'll show you the place. And once they show up and the landlord sees their disability, it's evident they have a disability, then the landlord backs off and stops talking to them and doesn't, maybe they hand an application and they never even hear back, okay? That's problematic. And that might be a situation where that they could prove that they were discriminated against. Linguistic profiling. Someone calls a landlord, they have an accent of some kind, and the landlord, place is rented. I'm sorry, it's not available anymore. It's off the market. We've already rented it. But the moment someone calls with no accent, and the landlord then says, yes, it's available, okay? Even though 5 people called prior to that with some kind of accent, or it was evident there was some kind of disability when they were speaking, okay? That's problematic, and that's definitely discriminatory. No children allowed. The only time someone can say that is when it's senior housing. There's some exemptions in senior housing that allow for them to say that, but they can't advertise that way. They can say senior housing 52 plus, or 55 plus or 62 plus. They can't ever say no children allowed. Under no circumstances can anyone ever advertise in a discriminatory way. We often see no Section 8, no HUD. That's discriminatory. Even if a landlord knows their property is not going to pass an inspection and or the rent is above fair market rent, they can never say no Section 8, no HUD in an advertising way. Many of you do not look that old here. I'm very old. Back in the day, prior to 1988, oftentimes we saw advertising that said no pets, no kids. And what that meant for families in Oregon, okay, that's why familial status was added at the federal level, because it was a problem across the board throughout the United States. But in Oregon, what that meant was nearly 70% of all families were denied access to housing because they had children in the home. So when, we see that no children thing still, we still get some landlords like, I don't want to rent to teenagers, or I don't want to rent to small children, okay, with families with small children. They can never say that. Now, do they sometimes? Yes, they do. You'll say, well, I've had an experience with teenagers before that destroyed my property, and I'm really leery about renting to teenagers, okay? Well, that's just their problem. They cannot ever say that and deny housing to a family who's got teenagers. Healthy and active seniors. Again, senior housing they have exemptions, but they still have to follow fair housing law. Even if it's a 62 plus community, they can never advertise in a way that would make someone feel like they don't belong. So stating something like seeking active, healthy and active seniors might make somebody with a disability have that chilling factor, that chilling feeling like I don't belong there, I'm not who they're looking for, okay? I wouldn't fit in. So even that type of advertising is problematic and it's illegal. We don't really get, and Stephen probably tap into this, we don't really get a lot of folks letting us know when they see illegal advertising. And I really don't know, what can we do? We test for that, Stephen? If we get that information?
We actually do find out about illegal advertising.
Okay.
The way we actually do find out about it tends to be our testing team.
Oh,
They are combing through people's websites looking for that type of stuff.
got it, okay.
When it comes to our attention, we'll usually give someone an opportunity to change it, or if they tell us no, for enforcement actions.
Got it, okay.
Make it an educational opportunity.
There you go. We do have some red flags here that we, at the Fair Housing Council, when we see these, of course, we're then questioning what's going on. If a landlord refuses to rent because of your disability, if they say, well, I see you're in a wheelchair and my unit's not really, accessible for that, it doesn't matter, okay? They're not the ones that are going to decide if the individual wants to live there or not. It's up to the individual. If they are next in line with their application, they pass the background, the landlord must offer that unit to them. It's up to that individual to decide if they want to live there or not. They have the right to ask for modifications. In some cases, they might have to pay for those modifications. But if it's federally funded housing, it's the housing provider who pays for those modifications, just so you know that. So if there's any kind of federal subsidy other than like the Section 8 or Housing Choice Voucher, that does not apply in this case. But other federal housing, some tax credit properties, migrant worker housing, all of those are federally funded. And when someone has a disability and needs a modification to that rental unit, it's the housing provider who pays for that modification. Makes offensive comments to or about others regarding their disability. That happens sometimes where an on-site manager or maintenance staff will make comments about someone's disability in a negative way. That's problematic and it's illegal. They cannot do that. Assumes that the individual cannot pay rent because of their disability. Again, just because they're on Social Security doesn't mean they can't afford their rent. Or maybe they get some kind of subsidy. Like Savannah said earlier. Yeah, go ahead, Pedro.
Are questions allowed?
Absolutely. We're a small group. Please ask. Yeah.
What about when they set a minimum requirement for income levels, right?
Mm-hmm.
Kind of ties up to what you were saying about assuming you can't pay rent.
Like the 3 times the amount of rent or 2.5 times the amount of rent? Okay. So how it works with subsidies. If an individual is receiving a subsidy that's going to be helping pay their rent, the landlord must go off the amount the tenant will be paying for that policy. So if the tenant is getting a housing choice voucher, Section 8 voucher, many of you know that as, okay? They have to pay 1/3 of their income towards their rent, and then the subsidy takes care of the rest of the rent. They automatically qualify, okay? But the thing is, a lot of landlords don't realize that. That's the niche when it comes to subsidy. It's what the tenant's portion is, not the full amount of rent when there's a subsidy involved, okay? Yeah.
What if it's not a subsidized unit, right? They're just going to a regular apartment in Portland. They have enough money to sustain on their own individual budget.
Okay.
But it's not 3 times the amount.
Okay, so we can thank HUD for this one, just so you know. HUD made it very clear that 1/3 of our income should go towards our housing costs, okay, back in the day. And so that's what landlords leech on, they grab onto that and go, well, if that's the case, I'm gonna require 3 times the amount of rent for income. All right, we all know that many people could get by on a minimal budget, okay, even though they don't earn or they don't have income coming into their homes that make 3 times the amount of rent. They can still pay their rent and pay their utilities, and they have enough to pay, whatever it is they have got going on there. This is the thing. If someone can demonstrate at the time of application, they have to do it when they apply. I would suggest that. I mean, I'm not going to say they have to, but it's always best. If they can show their landlord what income they have coming in their house, maybe they're also getting some SNAP benefits, maybe they're also getting some kind of subsidy of some sort for their transportation. They might even get energy assistance. They might get a free phone from Department of Human Services. If they can show all of that, that should be considered as income too. So it shows the landlord, I also have other ways to support myself other than the income I'm getting in my home through Social Security, okay? So be aware of that. Yes?
Is there a statement like on the HUD website or like blog versus online search
In regards to 3 times the amount of rent?
Yeah.
I could probably find something. If you want to give me your email before we leave today, I can find that when I get home. It won't be until tomorrow, just so you know. And I can email you that information from HUD when they said that income to support housing should be 1/3 of your income. I'm sorry. Money to support housing should be 1/3 of your income, okay? I think it's cost burden. Yeah, it's part of their cost burden analysis thing. So they've been saying it for a very, very long time, and that's how they determine fair market rent and other things, like the subsidy programs that are ran through federal programs and state programs, frankly, okay? Mm-hmm. They calculate the amount of rent, utilities the tenant pays, what types of utilities those are, gas, electric, so forth, how many bedrooms, is it an apartment, is it a house, like all this stuff goes into that calculation, and then this That calculation determines what their portion of rent is when it comes to those subsidies. I'm sorry. Okay, so if they're saying 3 times the amount of rent, it's because they have that backing in regards to what that cost burden is.
There's no law that says
There's no
they
law.
can't, so they can.
Yeah.
Essentially, what happened is they took this information that says, hey, this is what you should be kind of looking at and aiming to do, and they turned it into a requirement instead of using it as a guide, how it was intended.
And
So they
Stephen
can do that.
Yeah, Stephen can correct me on this one. Oh, that right there? Like, are you talking about like using the tenant's portion of rent as their guide? There are some cases that were settled out of court that I will send you, okay, that deal with that specifically, where the landlord is being sued and they decide real quick in a hurry they're just going to settle out of court because they don't want to go to court and lose. Okay, no court. We haven't had any cases go through the courts yet regarding that here in Oregon, but we've had some cases that got settled prior to that. Legislative intent was that we go off of what the tenant's portion is when it comes to source of income. Okay, if they have a subsidy paying the rest of their rent and they're required to pay 1/3 of their income towards their rent, they would have enough money to meet that requirement.
Maybe
So-
it'll help if we use some numbers to give them. So I use numbers because it makes it a little bit easier. So if I'm looking to rent an apartment at $1,500 a month and I get a voucher, how does that work?
We'll say this, you keep it easy, $1,000, okay? The thing is, it's not about the rent amount, it's about the income coming into the household. If they get $1,000 a month, they're gonna spend $333 towards their rent. That leaves them $666 to put towards their other utilities, the things they need for the month, whatever that may be. I believe I do have information, though, that I can send you. So if you leave me your email, I will send you that information. I'll send you those court cases that were settled out of court. And then I believe HUD also put some information out there regarding that, and I'm pretty sure I have that. Now, HUD now, their website has changed. A lot of things have been taken off of it, but I save things off of that previous website, so I have them on my computer, so I can find those and then send them to you, okay? Oh, Pedro. No, that's okay. Yeah, anybody who wants to leave me their email, I'll just put it like in a mass email and send it out to everybody, yeah.
Because I think what kind of happens a lot is that a person will have like an ARLA voucher.
Mm-hmm,
And it will cover any amount of rent up to a certain amount.
sure.
And then they come into housing and it's like, here's my voucher to cover the $1,000 rent.
Mm-hmm.
Which we pay only for rent, I cannot get any money back.
Mm-hmm.
But it covers all of it.
But do they have income on the side of that, though? They have any kind of income coming in their household? Okay, so this is the deal. When there's zero income, that's a different story. They've got to be able to show the landlord that they have the means to pay for the utilities, because it's part of usually it's part of their agreement they're going to be signing with the landlord, okay? Maybe it's electric, maybe it's water, sewer, who knows? So in those cases, I do know, not that it's going to work all the time, but what I would say is that individual at the time of application needs to supply to their landlord how they're going to be paying their utilities. Maybe they're applying for energy assistance once they get into housing. Maybe they have another agency that's going to help them with that. How they're going to be paying for their food. Maybe they get SNAP benefits. How are they paying for transportation? How are they paying for those necessities they need in the home? Shampoo, soap, toilet paper, whatever it is. How are they supplying those things for themselves? Everything you can think of. Are they getting a free phone from Department of Human Services? Whatever it is they're doing. Write that information down and provide that with the application, at the time of application. So the landlord sees, okay, rent's being paid for, utilities are being paid for, X, Y, and Z is being paid for. This person I don't have to worry about. Now, can a landlord deny? I'm not, I don't know. What do you think, Stephen? They could, but it'd be harder for them to do that, I think.
I mean, potentially, we actually have a case right now, I won't get too into the weeds, but we have a landlord denying Section 8 tenants that don't have savings in the bank. Their argument is that if they damage the property, they won't be able to pay the parent, which we think is I would say that policies like that, to the extent that they have disparate impact on people using Section 8 vouchers, are I agree with Glenda.
Mhm.
If they can itemize and show that their necessities are paid for and covered, even without income savings,
Mhm.
they should be able to show that they can afford to live there. And I think it would be discriminatory besides.
Yeah, I know that low-income housing, like through the Housing Authority, they have a zero-income form they use for that, those situations. Most landlords don't even, some landlords will say, well, do you have other means to support yourself? And they take that in consideration. Not all landlords recognize that there's a zero-income form out there, or should be looking at that also. It might mean that we have to do some education with some landlords. But once a landlord understands there's other ways this person's gonna be taking care of their needs in housing, then they usually kind of back off a little bit.
Source of income is one of those things where it really does involve a conversation and people understanding how it is intended and what it means and how reasonable they are with, wanting to work with people. There are a lot of landlords out there that are totally great working with people, and there are some that want everything to be very specific with how they want it.
All right, so move on. Raises your deposit, or do you have a question? Go ahead.
Sorry, actually, it's not on that topic, but
Okay.
reasonable accommodation.
Yeah,
So would you mind going a little deeper?
we're gonna cover those. Yeah, we'll get those, we'll cover those. Yeah,
I'm gonna-
and then if I don't answer your question, whether you can ask me. So raising your deposit or add other fees and stuff when they learn there's a disability, that happens often, especially with someone like who's in a wheelchair. The landlord's like, well, the deposit's $300, but I'm gonna make it $500 because those wheels are gonna be scuffing up my walls, right? Like, that's not okay, they can't do that. Wrongfully denies, for reasonable accommodation or modification requests, maybe at the time of application, someone's, submitting a modification or an accommodation request due to their disability, and they're denied based off that. It's hard sometimes to prove that because the landlord is not going to deny on that per se. They're going to find some other wonky way to deny them, but you know it's wonky. Okay, does it make sense? Refuses to investigate or intervene, and I'll tell you what that normally means. It usually means that they're told that the place is already rented, but they take their application fee and don't give it back. Okay, after they've asked for a reasonable accommodation at the time of application. So why'd you run my background? If it's already rented, why are you keeping my application fee? And now that I've asked this reasonable accommodation at the time of application, now you're denying me. So usually that's kind of the way it looks. Refuses to investigate or intervene with when harassed by neighbors or other staff when that occurs. So landlords or housing providers that refuse to investigate when a person with a disability says, I'm being harassed, okay, that's problematic. They have an obligation to look into that, to stop that behavior in any way that they see fit, whether it be giving out violation notices, evictions. They have to follow up with that person who's been harassed. There's some specific laws to that. And let's say maintenance staff witnesses harassment in some way, shape, or form, informs their landlord about that, or the on-site manager, for instance, the manager does nothing. That's problematic, okay? Anybody who should have known or would have known is going to be held accountable for that behavior, for not doing anything about it. So that means maintenance staff possibly, on-site manager, owner, property management company, all of them. Okay, so there's federal law specific in regards to liability and vicarious liability, and a lot of housing providers just don't know that. Yeah. So when someone gets punched, it's up to them to call law enforcement and say, I was assaulted. Okay. Yeah, they're going to do that. They don't hold them very long, but they're going to have court at some point in time. They'll be held accountable. Their responsibility for that. So I'm gonna ask this question. Can I ask what kind of hate speech it was? Okay. So they were making fun of somebody and saying some terrible things to somebody based off their gender identity. Okay. and then that person punched the person? Okay. It was the person that was harassing punched the person they were making fun of? Or was the opposite way with the person who was being made fun of punched the person who was calling them terrible names? You have two situations right there. Both of those people probably would have been evicted if I was the landlord, okay? Not saying that's right, wrong, or indifferent, but the thing is, we have one person who's instigating a situation verbally. They should have ended that right quick in a hurry, and that person should have been given violation notice, whatever it is the policy for the landlord. I can't tell you what the policies are for the landlord. They should have ended that right quick in a hurry. But the moment someone retaliates with violence, you also have that, you probably have a clause in your, and I'm not saying I agree with this, I'm talking about what your policies are. If you don't uphold your policies in every way for every tenant, then it could be discriminatory across the board. We don't want to do that. If I'm a landlord that says no violence on my property, if so, you're going to be getting an eviction notice, okay? And you cannot be harassing other tenants based off protected class status. Otherwise, you possibly could be getting an eviction notice. Anybody who's violating the law, the rules I have out there, I'm going to handle it like a violation in whatever way I need to, okay? So I'm not saying I disagree with the person who punched the person, okay? I'm not saying that. But I'm saying when there's rules in place, so for landlords, if they don't follow their rules, what ultimately happens is, well, that person did that and they didn't get in trouble and now you're evicting me because I did the same behavior, no matter the reasoning behind it. So just be aware of that. Landlords are kind of like walking this weird fine line where like, that landlord should have done something right quick and in a hurry though. That should have ended yesterday, okay? The moment they found out that they're treating someone poorly based off their gender identity, they should have nipped that in the butt right now. That should have never gone any further, honestly. And I mean, I would, understand that, but
Did the resident tell the landlord that they were being harassed?
I found out yes, and they did start a report.
Okay.
shame on that landlord.
Yes, so if the resident had never said anything, the landlord was unaware of it, that's different. But if the landlord is aware of it and does nothing, they are responsible because that inaction then resulted in the escalation.
Mm-hmm.
So it's not just the property management, but like we had front desk staff and
All of them are held liable.
They
of
all work for them, employees, maintenance staff, everybody.
Mhm. Every single one. Anybody who witnessed it, failed to do anything about it, didn't move forward with curing the problem, even the owner who may know nothing about it is going to be held liable for that. Yeah, they should be anyway. I'm really sorry to hear that happen. That's terrible. So in regards to harassment, housing providers must investigate and follow up when notified of harassment of any kind when it's due to protected class status, okay? And they need to have policies in place that they follow regarding that type of behavior, and then, and end it right now. Now we're getting to our reasonable accommodation and modifications. Oops. Okay, so reasonable accommodation and modifications always related to disability. A lot of people forget that. So a lot of times they're like, well, I asked for reasonable accommodation because I wanted, but there's no, I wanted something or I needed something, but there's no connection between a disability. There's no nexus, okay? So we got to remember that those two things are based off disability. Yes. Mm-hmm. Yeah. Have you really? I didn't realize people were, in Eastern Oregon, we don't get the electric vehicle charger thing, so I get, yeah, you guys probably have it way more in this area than we would out there. Interesting. That's interesting. So what is a disability? The definition of disability in the Fair Housing Act, it means a mental or physical impairment that significantly limits one major life activity such as walking, seeing, breathing, thinking, caring for oneself. It's very broad and inclusive. It's a different definition than like Social Security Administration might have, Department of Human Services, Veterans Administration. They all have their own definitions of disability, okay? Just because someone doesn't fall under disabled under like Social Security Administration doesn't necessarily mean they're not disabled under fair housing law. So be aware of that. A lot of times people think because they applied for Social Security and they were denied, they're not disabled, okay? Under their definition, they may not be disabled, but under fair housing law, they very well could be disabled. So be aware of that. So This includes people who have a history of such impairments, such as or perceived impairment. So if someone assumes someone has who's got a disability and they really don't, they're being treated differently because that person's assumption. Okay, they're protected under fair housing law. It also protects people who have a history of that. I said like earlier, controlled substance use or alcohol use. Okay, if they're clean and sober today. If they're actively using today, that's not a protection for them. But if they're clean and sober today and their substance abuse caused issues for them previously as a barrier to housing, and they've made a shift or change in their behavior, and they can prove that, they can ask for reasonable accommodations. So how to write a request, okay, so for reasonable accommodation. A request, an accommodation or modification, there's a couple things you gotta do. Figure out what type of request you want. Is it gonna be a modification? If so, that's a physical change to the actual unit. Now, under some housing, if it's federally funded, like low-income housing under the Housing Authority, multifamily housing, all of their requests are reasonable accommodations, just so you know that. But if you're renting from a private market landlord, it might mean that you have to ask for a modification. That's a physical change to the outside or inside of the building or the unit that's gonna make it accessible for you to have equal access to that unit, okay? It might mean grab bars in the bathroom, a wheelchair ramp installed of some sort, maybe some kind of flickering lights to assist you with knowing someone's at the door, whatever it may be, okay? Modified bathrooms or kitchens. How to make the request to a housing provider. It's important that people understand how that works. Now, we're gonna dive into that a little bit deeper. I'm not gonna get into too much of that now, but you need to understand how you should be making that request, what the housing provider might ask you, okay? And then providing verification. There are times housing providers can require a little bit more information, especially when it comes to reasonable accommodation for assistance animals, when multiple animals are being asked for. If there's not a clear reason why the animals are needed, okay, the housing provider has every right to say, okay, I need to know what each animal does. It's different than the other animal. If someone's asking for 3 cats as emotional support animals, that housing provider has the right to go, okay, you're asking for 3 cats for emotional support animals. Do they do anything different than the other cats do? Do each of them do something different that provides a service to you or some kind of therapeutic support that the other ones can't do? Okay? They have the right to ask that. And if that individual can't provide that information to the housing provider, they can say, okay, I'm only going to honor 1. I'm sorry. Okay, we normally have a no pets policy, but I want to honor all 3, but you can't provide me enough information to make that determination. So I'm going to honor 1. So what are we asking for? So a physical change to that unit, again, is a modification. When you ask for an adjustment to the policy, rules, or procedures, that's a reasonable accommodation. So be aware that those are distinctive in regards to what they mean. So an accommodation or modification can be asked for at any time during the housing process, during the application process, during tenancy, and even after receiving some kind of violation or eviction notice. When an eviction notice or a violation notice has been issued, that request, that reasonable accommodation, must be able to cure the problem. So maybe someone is disabled. They have, is it almost noon? Is it really? No, it's not. That thing, okay, so this computer's got the wrong time on. I'm like, holy cow. Okay. So with that, if in regards to violation or eviction notice and reasonable accommodation, if someone's making too much noise, they keep on getting noise violations, and then all of a sudden they get an eviction notice because they've had 1 too many noise violations, they have every right to ask for a reasonable accommodation if that accommodation can cure the problem. Maybe it is, I need some soundproofing, a modification to my unit, okay? Or maybe it is, I'm not engaged with my mental health services anymore. I have an appointment next month with my mental health provider to get back on my medication. Can you please work with me until until that happens? So that's what I'm talking about in regards to having a cure to the problem. They can't just say, I'm disabled and I need you to just let me be as loud as I want. Okay? They have to be able to cure that problem. They can't just keep on going on the path they're going with no resolution to it. Landlords have every right, tenants, other residents that live there have the right to peaceful enjoyment of their premises, their unit, and if they're being just harassed and or unable to have peaceful enjoyment because of noise from other tenants, they have the right to complain about that. So request during application, when making a reasonable accommodation during application, is usually because there's a past barrier that's prevented them from passing a background, okay? It could be due to the past eviction, poor criminal history, credit history, so forth, that amount of income they're getting. It could include asking for a modification to a doorway to ensure safe and equal access to the unit, or other types of accommodations, okay? So can a landlord, I'm gonna try to get through this, we're done at 12:30, 12:15? What time are we done? I'm sorry, 10:15? Okay, we're gonna bust right through this. And then I'm gonna ask any questions that you may have regarding reasonable accommodation. Can a landlord require that the reasonable accommodation or modification request be submitted to a certain way? Well, they need the information on there regarding what it is you're asking for, okay, and how it's connected to your disability. And if they can't see that disability, it's not visible to them, they don't, it's not evident, they can ask for verification from your provider. They can have forms there for you to use and your provider to use, but they cannot require you use those forms. They can say, this is the form I have, the information listed on this form is the information I need. You can use this form, your provider can use this form, or you can provide me with anything else as long as this information is covered, okay, in regards to the request. Housing providers must accept verbal requests. I'm gonna say this, verbal requests are fine. Anybody can ask for a verbal reasonable accommodation or modification, and landlords should accept those. The thing is, there's no paper trail. So it's easy for a landlord to say, well, you never asked me for that, okay? And if there's no verification of that, right, it's harder to prove. Unless someone's actually documenting everything, then it might be a little bit easier. But the thing is, it's always best if done in writing because there's a paper trail. Tenants should also keep a copy of everything they give their landlord. If they're giving, asking for reasonable accommodation, they keep a copy of that reasonable accommodation and the verification letter. If they're asking for a maintenance request, they keep a copy of the maintenance request, okay? Because all too often, folks that are disabled will ask for those modifications or reasonable accommodations, and they're never acted upon because they don't keep documentation on it. And they might need that special thing in that rental unit, and they don't get it because they don't have any proof they ever asked for it, okay? So be aware of that. So requests during tenancy, the reasonable accommodation or modification request can be submitted while residing in the unit, but no matter what the request is, remember all tenants must be able to follow the rules. They can't just say, I'm disabled, therefore I want. Okay, they have to be able to provide verification if their disability is not evident and if the request isn't linked to the disability. Okay, they have to be able to show there's that connection, that nexus. Here's some examples really quick. It might be someone, again, needing to have a soundproof room. I'm not going to get into all these because we're hurting for time. Or that noise sensitivity, heightened noise sensitivity where someone might use earplugs when they're sleeping, but they need to be aware of like the fire alarm going off or something, so they need some kind of flashing device to wake them up if that were to happen. Let's see here. Someone who's got a traumatic brain injury who's pretty forgetful, who might need to ask for reasonable accommodation for the landlord to remind them to pay their rent on time. We see that one often. One that we see a lot is someone who uses their patio or their deck to store something they need, like a bicycle for that's their transportation, but yet there's some kind of policy by the landlord that nobody can put things on their deck or patio, which is absurd to me because why would you have a deck or patio, right, without putting something on it? But yet they let people put like their patio furniture or potted plants out there, but they don't let someone store a bike out there. That's problematic. And we also see those with families with children. You have a sand table or a water table out on the patio or a few little toys or a child's bicycle and they get written up for having something on their patio or deck. That's not okay. And maybe that doesn't happen here in Portland as much as it does in rural communities, but in rural communities, landlords all the time in apartment complexes will tell you can't put anything on your deck or patio. It doesn't make any sense whatsoever. So here's an example of a letter template. And I'm just going to go to the nitty-gritty of it. So it says, in regards to reasonable accommodation, as defined by the Fair Housing Act, I'm a person with a disability. In accordance with fair housing law, I'm asking for a reasonable accommodation to have my rent due date change from the 1st of the month to the 8th of the month. This request is necessary for me as a person with a disability to maintain my housing and pay my rent in a timely manner without incurring a late fee. With the request, I have included my Social Security disability statement that shows my payment date of the 7th of each month. So they get their Social Security on the 7th of each month after rent is due. And they're wanting to be able to pay their rent without getting dinged a late fee, okay? So please respond to this request. It's always important you give the landlord a week or two to respond and put a date on there. And then it should be the tenant's name, their unit, and the date it was submitted. Those are super important, especially for enforcement back there. They want to know when that was submitted, and they want to know what the request is. They want to know there was proper verification provided with it, and they want to know also what time frame you gave the landlord to respond to you by. Again, I can send this to anybody who wants to leave their email with me at the end of this. I can put a PDF copy of this presentation in that email that I send you. So verification, once the disability is evident, for example, use of a wheelchair, you will need to submit verification of the disability. So who can provide verification? So verification is supporting documents stating the person has a disability in regards to that reasonable accommodation or modification they're asking for, okay? It's connected to it. A verification letter that is written by a qualified individual, it's a disability statement document and a program completion certificate or more. It could be anything that's related to that disability. Someone who's completed substance abuse treatment, it could be that certificate of completion of their treatment program. Someone who's on Social Security disability benefits, it could be that letter they get yearly from the Social Security Administration telling them how much they're getting that year, when their payment date is, all that stuff. It could be a letter from a doctor, a therapist, nurse practitioner, okay? Any of those people are qualified. Yes, Stephen?
I would just like to add, because this is a common point of confusion for property managers. The verification letter is not to verify the need for reasonable accommodation. A lot of housing providers will send someone back and say, your doctor needs to say you need this reasonable accommodation. No, your doctor just needs to see the disability. The tenant gets to decide what is necessary to accommodate them.
Absolutely. So it's someone who's like in recovery. It might be their sponsor who writes their verification letter for them. That's someone they work with on a regular basis who understands their need or their disability, okay? I will give you this example. I see a doctor for my thyroid, okay? And I walked into her office one day, and on her front counter, there was literally a legit sign that says, I will not write verification letters for assistance animals. I'm like, what? Of course, that intrigued me. So when I get back to see her, I'm asking her, what is this about? Like, she's like, Glenda, I don't see people for their emotional, it's just, I see people for their endocrine problem, their endocrine system. When someone tells me they're having a hard time with their mental health, and she's like, I understand endocrine problems can cause mental health issues, depression, anxiety, whatever it may be, I refer them to another doctor. I don't see them for those problems and those issues. I know nothing about that. So when someone comes in here and says, I need an emotional support letter, a letter from my emotional support animal due to my mental health, she says, I don't see people for mental health. That's why I won't write those letters. Now, if someone says, I'm coming in here because I have this service animal because of my low blood sugar, all day long I'll write that letter, okay? So that makes sense to me. It's someone who understands the need for the animal, who's working with that individual, understands their need for the reasonable accommodation in general, okay? So qualified means the person is familiar with someone's disability and how that affects their life. They do not have to hold a specific certification or license to be qualified. However, they must have a professional relationship with that individual. So it could be doctors, medical professionals, therapists, psychiatrists, psychologists, occupational therapists, case managers, social service providers, religious leaders, so forth. All right, at this point, any questions? Did I answer your questions? If not, I'm going to dive into it right now. Yeah, good.
And just as a heads up to anybody who might be in a job position where you might be able to write reasonable accommodation modification letters, but you may not feel confident or maybe don't think you feel comfortable writing them, we can help you with that. And we can provide training and education that can help you be efficient and doing them the right way.
If you know someone who's being discriminated against and they want to report, or you're an advocate on their behalf, go to our website at www.fhco.org. At the very top of the main page is a red box that says Report Housing Discrimination. If you scroll down, there's one for applicants or tenants to fill in that information. If you go scroll down even further, there's one for advocates, okay? Or you can call the hotline on Tuesdays and Thursdays. It doesn't say Thursdays on here, but it's Tuesdays and Thursdays from 9 and noon at this number given. there are some things they need to know, okay? So your name and contact information, the name and address of the property, you're reporting which protected class is being discriminated against, and dates of the discrimination occurred and what occurred. We also have a library you can go to get all kinds of information. This materials are in our library, as are other education materials. We also have some pre-recorded trainings that are there. And if you have questions about, in general, about fair housing, information at fhco.org. Just ask your question and we'll get shot off to the correct person to provide that information to you. And for those of you who want me to send you an email, I'll grab your email up here now. You're welcome. Thanks for being here. How are you doing? And I thought I grabbed my business cards and I don't have them on me. But here, what I'm going to do, I'll just take this. Yes. No, yeah, I'll meet. Oh, yeah, through the Fair Housing Council. I'm right there. My email's there too. So, yeah. Thank you. Yeah. I was late. We were all late because this room doesn't exist on our thing. It said E150, and I was like,
Makes me wonder how many people, because there were people that told me they were going to come to my session, but I don't even know if they could find the room.
There were several people that I heard, like,
yeah.
Yeah.
Yep, take care, Pedro.
The map was deceptive.
Thanks for showing up, man.
I was late because I was looking at
Me too. I was late for the same reason.
I didn't even know there was a whole back half of this until this morning.
first session I had over here.
Because I haven't went past the staircases and elevators, so I was like, wow, there's where all the tables are.
Pedro's
I know, I'm like, I'm gonna go walk through, go get the other swag stuff that I didn't get to look at.
I gotta drive home. Yeah, to flex my time today.
Oh, yeah, absolutely. Your driving times.
4 hours. Yeah. And then, so I won't work the rest of the day. I'll probably be taking Friday off. Thank you so much. Yes. I'm gonna email her. Yeah, my driving time in itself sucks up half my time.
How long is it?
It's usually 3.5, but if I stop to get gas or grab something to drink, it becomes 4 hours. Yeah. It's not too bad, no. Oh no, I would be flying all the time if I was her to come up here. There's no way in heck you're gonna get me to drive from Medford to here